Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today's topic for discussion is very interesting. It'll be on rights of a woman at workplace, both in theory and practice. And today we are joined by the very articulate, the very eloquent Mrs. Shaambhavi Bhansali Mardia. She's an advocate by profession practicing before Honorable Rajasthan High Court at the principal seat, Jodhpur. And although she needs no formal introduction, but the format of our channel is such that we do give an introduction just to familiarize the audience with the amicus for today's session. Now, Mrs. Shaambhavi Bhansali Mardia, she's been practicing. She's an advocate and legal consultant at Honorable Rajasthan High Court since 2016. Prior to that, she worked as a legal consultant with UBTech Solutions Private Limited. Prior to that, she worked in the esteemed chambers of Sri J.P. Sen from 2015 to 2016. And she has done and studied law, which is BLSLB from Government Law College, Mumbai, back in 2013. And subsequently, she pursued a PG diploma in international humanitarian law. And she also secured the All India third rank from the very prestigious Nalsar University, which is a National Academy of Legal Studies and Research University at Hyderabad. So thank you so much, Mrs. Mardia, for taking out time. Sorry we spoiled your Sunday evening plans. You could have done something far more productive than featuring on one of the sessions on the virtual amicus. So anything that you wish to say before we start with our segment?
Yeah. Thank you, Jai, for such a lovely introduction. I just want to say how grateful I am to be on your platform and how commendable it is what you're doing, taking out time to do something for the students, for other lawyers. That's commendable that you've taken this initiative and you're, ensuring that somebody or the other comes with a good topic to enlighten other people. So thank you so much for considering me worthy enough to be here, and I just hope this endeavor takes the best of heights for you.
Thank you so much for all the kind words. They really mean a lot to me and my entire team. So without wasting any further time, the stage is set. The floor is all yours. Over to you.
Thank you so much, Jay. Hi, everybody. Today I'll be speaking on some of the basic rights every woman is entitled to at her workplace. I've also curated some cases which bring forth the glaring inequalities and interesting judgments pronounced by the courts of our country to enforce and implement these laws in their true spirit. I have also tried to bring forth to you guys what you can do in case you or someone you know has been wrong. So, before I begin with the legal part, let me throw in some numbers. India's substantial increase in GDP per capita has not been matched by progress towards women's equal economic participation. The country's female labor force participation rate stands at just 27% compared to global average of 49%. Not so shocking is the fact that all across the globe, despite having legislation similar to that of India, no country has been successful in fully eradicating the gender pay gap, although some have narrowed it considerably. Now, more than a third of Indian women, and that's a big number, primarily engage in housework, report wanting to work for pay if a job was available to them. The IMF, the International Monetary Fund, finds that India's GDP will increase by as much as 27% if women participated in the economy at the same rate as men. India has a gender wage gap of 34% despite the existence of Article 14, which calls for equality before law, and Equal Remuneration Act 1976, which mandates equal pay for the same or similar work in all the organization. So now let's move on to the law. What are the important legal rights of a woman in India? The first document that I'll be speaking on is the Constitution, which is one of the most important document for every citizen because it is in this document that we have our rights entailed. Now, the Constitution of India mandates that women must be treated as equals and prohibits any discrimination against women, including in education, vocational training, skill development, and employment. Article 14 guarantees equality before law and equal protection of law to all its citizens. Article 15 takes this principle a notch further and prohibits discrimination on the basis of religion, race, caste, sex, or place of birth. And Article 16 provides further that equality of opportunity must exist in all places of public employment. Not only these fundamental rights are available to a woman, the Constitution also in its directive principle of state policy states that the state shall ensure that health and safety is duly protected in the course of employment, particularly those of pregnant women and breastfeeding mothers. Hence, if any law is passed or any action is taken to prevent women from taking up employment in government or public sector undertaking, such law or action by the concerned authority can be struck down by the Supreme Court or a High Court as being against the constitutional provisions. Now, let me talk about one of the very recent judgments which caught a lot of media attention. The Secretary, Ministry of Defense versus Babita Punia. This was decided on 17th of February 2020 by a division bench headed by Justice D.Y. Chandrachud. So, what were the facts of the case? Now, in 2003, Babita Punia, an advocate, filed a PIL before the Delhi High Court asking that who are engaged on short service commissions in the army must have parity with their male counterparts in obtaining permanent commission. Now, what are these commissions that I'm talking about? In the Indian Army, short service commission refers to an officer's tenure, which is initially for 10 years, and then you have an option of prolonging it for 4 more years. Now, after this completion of 10 plus 4 years, the women officers have to compulsorily opt out, but the male officers have the option of taking up permanent commission. What is permanent commission? Well, permanent commission in Indian Army means a career in the Indian Army till you retire. So while a man can work all the way to his retirement age in the Indian Army, a woman had to compulsorily retire after 14 years. Now, when the case came before the Delhi High Court, it allowed the PIL and granted women who had entered the army on short service commission to permanent commission. The Union of India appealed against this decision before the Supreme Court and stated that made its argument and stated that one, the government has to take into account the inherent dangers involved in the services of the army officers. The next argument that they advanced was that the adverse conditions of service, which don't include privacy in war areas, insurgency areas, or in any field, makes it difficult to deploy women in those places. And thirdly, it argued that maternity and childcare issues are always connected to a woman, and therefore they are not entitled to receive permanent commission. Now, such were the arguments made by the government of our country. The Supreme Court bench, led by Justice D.Y. Chandrachud, struck off these provisions to be a clear violation of Article 14 of the Indian Constitution. And he beautifully worded his judgment, which I'd like to read. Um, Underlying the statement that it is a greater challenge for women officers to meet the hazards of service owing to their prolonged absence during pregnancy, motherhood, and domestic obligations towards their children and families is a strong stereotype which assumes that domestic obligations rest solely on women. Reliance on the inherent physiological differences between men and women rests in a deeply entrenched, stereotypical, and constitutionally flawed notion that women are the weaker sex and may not be able to undertake tasks that are to others. Arguments founded on the physical strength and weaknesses of women and men and on assumptions about women in the social context of marriage and family do not constitute a constitutionally valid basis for denying equal opportunity to women officers. So basically, the court held that the prohibition upon the grant of PCs to women in command appointments is violative of Article 14, and it noted that the army bore the burden of justifying such exclusion and that it could be done only on case-to-case basis. Now, ironical is the fact that all the arguments that the Union of India come forth with regarding the marriage, pregnancy, lack of privacy, in spite of all these arguments, the fact remains, which they placed on affidavit, is that 30% of the total women officers are in fact deputed to conflict areas. So, such a contradictory stand taken by the Union of India and its pleas and what they're doing in action. The second case that I'm going to speak about is Khurana and others versus Union of India. Now, this is a judgment of 2014. What were the facts of the case? The Cine Costume Makeup Artists and Hairdressers Association of Mumbai was registered as a trade union under the Trade Union Act 1926. Now, the association's bylaw prohibited qualified women and makeup artists from becoming members of the association solely on the basis of sex. Ms. Khurana, a women makeup artist whose application for membership to the association was rejected, challenged this prohibition on the ground that it violated A, her right to equality, her right to employment, and her right to livelihood. When the matter came before the Supreme Court struck down the association bylaw as being violative of Article 14, 15, and 21. And although the court acknowledged that fundamental rights in India are enforceable only against the state and its authority and not against purely private individuals, it found that a clause in the bylaws of a trade union registered under the Trade Union Act 1926, which is accepted by Registrar of Trade Union, is a state authority under the Trade Union Act, cannot violate the Indian Constitution. So this, in effect, the court went a step ahead, and it also contained within its ambit an organization which is registered by the state to adhere to the principle of equality before law. So this was the constitution. Now let's talk about women rights under the various labor law. But before I dive into what are these labor laws, let's ponder over whether enacting special law for women amounts to discrimination. No, it does not. Why? The power to enact special laws for women is given to the legislature under Article 15.3 of the Constitution, which stipulates that providing for additional safeguards to women is not discriminatory, but will enhance the principle of equality as it will help women to overcome the wrongs they have suffered for centuries. So, in essence, you can have a special legislation in order to uplift a section of the society which was wronged over the ages. Now, the three laws now that we'll be discussing are one, the Equal Remuneration Act, two, the Maternity Benefit Act, and three, the Protection of Women from Sexual Harassment. So, let's first talk about the Equal Remuneration Act. The Equal Remuneration Act 1976 safeguards the women's right in so much as it creates a legal obligation on every employer to pay the same wages to men and women if they perform the same work or work of a similar nature. Thus, in matters of recruitment, promotions, training, and transfer, the employer is prohibited from discriminating against women. So, in this regard, let me now speak about a very interesting case. It's called Air India versus Nargesh Mirza. It's a 1981 judgment of the Supreme Court. In this case, Regulation 46 and 47 of the Air India Employee Service Regulation was challenged. So, what were the Regulation 46 and 7? Under Regulation 46, while the retirement age for flight pursers was 58, air hostesses were required to retire at 35 or on marriage if they married within 4 years of joining the service or on their pregnancy, whichever occurred earlier. And under Regulation 47, this period could be extended at the behest of the managing director. In accordance with Air India's designation, the male cabin crew shall be referred to as air flight pursers, and the female cabin crew would be called air hostess. Now, these service regulations had created a significant amount of disparity between the pay and promotional avenues of male and female. When the litigation came about, there was various rounds of litigation, and both the tribunals below had successfully upheld the regulation, making observations such as the necessity of having young and attractive air hostesses to deal with temperamental passengers. When the case finally came to the Supreme Court upheld the regulation in part, stating that there are two separate and different classes having different conditions of service and different incidents, and the question of discrimination does not arise. Now, this was a judgment that was not taken well by a large section of the society, and it got a lot of disapproval. Why? Because in Nargesh Mirza, uh, the constitution of the cadre was itself on the basis of sex. Now, in service law, we are all aware there are different cadres within the same department with their own separate recruitment rules, promotional avenues, and service conditions. But that itself does not raise question of Article 14, violation of Article 14. But in Nargesh Mirza, by definition itself, only women could become air hostess and only men could become air flight persons. Instead of starting off by examining whether this initial sex based classification was in conformity with Article 14, 15, and 16, the court instead began by noting that because the service conditions and promotional avenues of the two cadres were different, therefore they formed separate classes and could therefore be legitimately be treated separately. Now, this is a very wrong way to approach the gender issue, in my opinion, and this is why it caught a lot of ire of the public. But this was later in 1987 given its true meaning in the case of McKinsey and Company versus Audrey D. Costa. Now, this is again a landmark case. It was decided in 1987 by a division bench of the Supreme Court. What were the facts of this case? Now, in this case, the respondent, Audrey, filed a petition before the adjudicatory authority under the Equal Remuneration Act, alleging that during her employment, she was being paid remuneration at a rate less than her male counterparts, male stenographers, and that she was entitled to difference between the remuneration paid to her and the other male stenographers. When the matter reached the Supreme Court, the court held, let me quote it, once it is established that the lady stenographers were doing practically the same kind of work which the male stenographers were discharging, the employer is bound to pay the same remuneration to both of them, irrespective of the place where they work, unless it is shown that the women are not fit to do the work of the male stenographers. Nor can the management deliberately create such conditions of work. Note, this was what was done in Air India. They created that space. But what does McKenzie says? Nor can the management deliberately create such conditions of work only with the object of driving away women from a particular type of work which they can otherwise perform with the object of paying them less remuneration elsewhere in its establishment. Thus, what did the court do in McKenzie? It emphasized that in deciding whether a classification is unequal or not, it would consider the nature of the work involved and not a criteria that could not itself be explained without resorting to discriminatory justifications. Now, if a person, now let's see what is the remedy that a person has in case you are being paid less than your male counterpart. What you can do is you can take rescue under the Equal Remuneration Act by placing a complaint before the labor officer under whose jurisdiction either you are residing or the organization falls. Simultaneously, you can also club your complaint with violation of Article 14, 15, 16, 19 to prefer a writ petition before the High Court or the Supreme Court. Now, the next act that we'd be talking about is the Maternity Benefit Act 1961. A Maternity Benefit Act stipulates that every woman shall be entitled to and her employer shall be liable for the payment of maternity benefit. Now, this act came into effect in 1961, and in 2017, it was considerably amended to regulate the employment of women for certain period before and after childbirth. So, who all come within the ambit of maternity benefit? Like, which organization are bound by the provisions of the Act? All the establishments, whether under government authority or not, are supposed to give benefit of maternity act to all its female employees. The Act is also applicable to both unorganized sector as well as private sector with more than 10 employees. So it's not just restricted to government organization, even if it's a private company and even if it's an unorganized sector, as long as the number of employees engaged are more than 10, you're supposed to give effective Maternity Benefit Act. And then the maternity leave is applicable not just to the permanent employees, but also to contractual employees. Now, how are the leaves provided for under this act? How many weeks can a woman take off under the garb of maternity leave? So, after the amendment of 2017, now the maternity leave has increased from 12, which was in 1961, to 26 weeks, right? In case, and not only during your pregnancy, there are other situations as well where you can take leave. For example, in case of miscarriage, a woman is entitled to leave with wages at the rate of maternity benefit for a period of 6 weeks immediately following the date of a miscarriage. If you have adopted a child under 3 months of age, or if surrogacy comes into picture, you are entitled to 12 weeks from the date when the child is handed over. Even women who are undergoing a tuberculosis operation can get a paid leave of 2 weeks following the operation. And in case after delivery or miscarriage you catch on some illness, then you are entitled for a further period of 1 month over and above what is allowed. The employers are also under an obligation to inform all women employees in writing and electronically about the maternity benefit policy at the time of hiring itself. Now, the amendment introduces a very interesting concept, and that has become very relevant, especially now. It says, the amendment of 2017 says that work from home discussion with the women employee returning from maternity leave, if with the mutual agreement between the employer and employee, a work from home option can be provided, the same should be evaluated. So basically, even if that 26-week period is over, as long as the employer and employee are able to come up with some kind of agreement, work from home options should be explored by both the parties. So, how much remuneration are you entitled to if you go on a maternity leave? The maximum period for which any woman shall be entitled is 26 weeks of pay, and the additional benefits along with the paid leave that you will be entitled to would be medical bonus, nursing breaks, creche facilities, and once you resume work, you can have 4 visits a day to the creche, including the interval for rest. Now, um, can an employer dismiss the employee during her leave for pregnancy or deny working from home? Well, where a woman absents herself from work in accordance with the provisions of this act, it shall be unlawful for her employer to discharge or dismiss her during or on account of such absence or to give notice of discharge or dismissal. Now, let me speak about two recent case laws regarding maternity leave. One is Dr. Mandeep Kaur versus Union of India. This was decided in 2020 by Himachal Pradesh High Court. What were the facts of the case? Now, the petitioner was a medical officer. She was employed on contract basis at a clinic set up by the state of Himachal Pradesh. She applied for maternity leave, which was refused, stating that her contract of employment with the clinic did not have any clause under which she could claim maternity leave. A petition came to be filed before the High Court. The High Court, what did it hold? It held that stripping of a woman employee from her maternity leave benefits, including leave without pay, equal to exploitation of the woman, thereby amounting to infringement of Article 21, which is like if you deny a woman of her maternity leave, it's actually an infringement of right to life. Additionally, it would not only result in taking a toll on the woman carrying the child in her womb, but would also impact the child's health. The High Court, while relying upon a landmark judgment, Municipal Corporation of Delhi versus Female Workers, this is the 2000 judgment, went on to uphold that maternity leave is available to women employees whether permanent, casual, or contractual, right? So even casual and contractual employees, like I said before, are entitled to maternity leave. Now, the next case that I'll be speaking on is Tanuja Tholia versus State of Uttarakhand. This is a High Court judgment of 2020. Uttara High Court uh, delivered this judgment. Now, in this case, a petition was filed by a female Ayurvedic doctor who was employed in the state health services on a contractual basis. Now, this woman was again employed on contractual basis. Though her contract of employment was for 1 year, it was renewed from time to time. Now she applied for maternity leave and it was granted to her. But after her maternity leave expired, she chose to not rejoin and applied for child care leave (CCL), which was denied, stating that since she was contractual employee, she could not avail CCL child care leave and it was available only to permanent employees. The doctor approached the High Court of Uttarakhand by way of writ. The writ was decided against her. The matter went to division bench. The division bench referred the matter to a larger bench, and the larger bench held as under. The court observed that the CCL's real beneficiary was the child, and the mother or the father taking the child care leave were only an instrument for enforcement of the child's right, and no discrimination ought to be accorded between who's entitled to CCL as the ultimate beneficiary remains the same. So the court essentially said that CCL is not about the mother, it's about the child. So irrespective of whether you're a permanent, casual, contractual employee, the leave is for the child and therefore a woman is entitled to it. But of course, that should be given on pro rata basis, because to a permanent employee, you have 730 days that you can take under the head of child care leave. And since contractual employment is usually for 365 days. Obviously, you cannot avail 731 days. So it has to be given on pro rata basis. And on that ground, this Ayurvedic doctor was given CCL paid leave of 31 days. Now, always please keep in mind that the Maternity Benefit Act is 1961 is a central legislation, and your service rules will also have its own provision as to how you can take maternity leave, how you will be paid. So always refer to your service rules as well while seeking maternity leave. So in case where can you take your grievance in case an employer refuses to give you your maternity benefit or any other amount which you are entitled under the Maternity Benefit Act? You can make a complaint to the inspector appointed under the Act. The Act calls for appointment of an inspector in this regard. And what if an employer fails to do the needful? An employer found guilty of withholding payment or infringing rights under the Maternity Benefits Act shall be punishable with imprisonment, which may extend to 3 months, or with fine of 500 rupees, or with both. Alternatively, you can also file a writ petition claiming violation of Article 14, 15, and 21 of the Constitution. Now, the third act that we'd be talking about is the Sexual Harassment at Workplace Prevention, Prohibition, and Redressal Act 2013. I'll be referring it to as the POSH Act of 2013. Now, the sense of security at the workplace will improve women's participation in work, resulting in the economic empowerment and inclusive growth. Only if I feel safe at work will I want to work for long, and would I be confident enough to take up work, right? So the POSH Act protects women in the workplace from sexual harassment. So who all women are covered under the POSH Act? So all women employees, regardless of whether they're employed regularly, temporarily, ad hoc, or daily wage basis, whether they are employed directly or through an agent or a contractor, whether they are employed with or without the knowledge of the principal employer, whether they are employed for remuneration or on voluntary basis, whether the terms of employment are expressed or implied, all are covered under the POSH Act. And the POSH Act applies to all the organized as well as unorganized sectors in India. private as well as um, organizations run by the government. Now, what do I mean by sexual harassment? What amounts to sexual harassment under the POSH Act? Now, any physical uh, contact and advances, demand or request for sexual favors, making sexually colored remarks, showing pornography, or any other unwelcome physical, verbal, or non-verbal conduct of sexual nature would amount to sexual harassment under the POSH Act. And how do you identify workplace? Because it's sexual harassment at workplace. So what is workplace under the POSH Act? Under the Act, workplace has been defined as that which means establishments, enterprises, institutions, offices, branches, premises, locations, units owned, controlled by the company, or places visited by the employees during the course of the employment. Basically, any place that a woman employee visits during her course of employment would be covered under workplace under the POSH Act. Now, by various judgments, extensions have been given to workplace. For example, team outings. Now, team outings are destinations that get covered under the purview of workplace, as the said outing is organized and controlled by the employers, and the outing has been attended during the course of employment. So, all these retreats that law firms take us to, or any company takes us to, that is considered as a workplace under the POSH Act. Cyberspace. Nowadays, business activities are conducted through video or audio teleconferences. Even especially during the times of COVID, work from home has pretty much taken over physical workplace. So even if there is some sexually colored remark action done during a conference, such act will also fall under the purview of the act. Now, cab services also are covered within the ambit of POSH Act. Renting cabs for daily commute is a common occurrence. And we've been listening every now and then that the driver molested, or he passed on some untoward remark towards a woman. So the court has held that as inside of the cab is an extension of the workplace of the driver, of which the employer is in control. Therefore, the safety of the women passengers commuting the ride it is the duty of the employer, and it is also covered under the POSH Act. Food delivery services. Recently, there have been instances where customers have complained of harassment from food delivery partners. This also falls under the purview of the POSH Act, and the employer must make sure that the employees they are recruiting do not engage in such kind of behavior. Now, there are two cases that recently caught a lot of limelight of the media, and I'll be talking about them. And why I've chosen to talk about these two cases, because both the cases are against women police officers, and the officers who are supposed to protect us are themselves the victims, and they're all happening at the top level. So imagine how pervasive sexual harassment is. So let me just talk about it. Into August 2018, a woman officer filed a written complaint against one of the top police officers in Tamil Nadu, S. Murugan, alleging that the officer would call her at night, note what amounts to sexual harassment, would call her at night, ask questions that were too personal, or would call her to his office where the conversation would be towards the way she dressed and her looks. She sought that criminal action be initiated and protection from him be granted to her, so that he cannot contact her or her family. Now, in spite of her being a police officer, and in spite of the person being accused being at the top in the state of Tamil Nadu, she has still not met justice. Seven court orders, a slew of petitions, and more than 3 years after, what is the status? S. Murugan was the accused, who was a joint director in the Directorate of Vigilance and Anti-Corruption when he was accused of sexual harassment in August 2018, remained in his post for another 13 months before being transferred. and he's presently Inspector General Special Task Force Iran. So basically, nothing has happened, and he's still going about doing his job. And even though it caught media attention, even though it is before various high courts, the case has not seen its culmination. It is not to discourage you, but just saying that that's sometimes how much time it takes for justice to be met. Now, the other case that I will be speaking of is is about a senior IPS officer in the rank of Director General of Police. Now, he was accused by a serving woman IPS officer who was a superintendent of police. The woman stated that while on duty inside a car, the senior officer, note the sexual harassment action, allegedly asked her to sing a song and then held her hand. He then allegedly kissed the back of her hand despite her expressing discomfort over this behavior. Now, all of not the act in itself, but then when the woman went to make a complaint, it was caught on camera how various police officers were blocking her way. So, in spite having an evidence right in her face, let's see whether she was met with justice. The Madras High Court took suo motu cognizance of the matter and ordered day-to-day trial of the case and directed the CJM, the Chief Judicial Magistrate trying the case, to complete the proceedings before December 2021 and submit its compliance report. Now the officers went before the Supreme Court, and I am a little disappointed by this judgment, even though it must have been passed in the right light. The Supreme Court stayed the order and further said that the trial court in Vilupuram should proceed with the case purely based on its merit without being influenced in any manner by a series of orders passed by the High Court. And it also the Honorable Supreme Court also put a stay on this matter before the Madras High Court. So, but having said that, sometimes it's not very encouraging. What is the point of going when it will take so many years? But the point is, when such things catch media attention, or when these cases rise in number, you are in effect creating awareness around the topic, and you're making people more sensitive to the issue. Sometimes people don't know any better, so it's always prudent. It's always necessary for you to raise your voice against wrong done to you or to someone you know. So so then that gets me to my next topic. Where should you file the complaint? The POSH Act requires an employer to set up an internal complaints committee at each office or branch of an organization employing 10 or more employees to hear and redress the grievance. And the complaints committee has discretion to suggest the penalties after having heard both the parties. Any aggrieved party can also appeal against this decision of the internal committee. Now, the second option that you have is the district officer is also required to constitute a local complaints committee at each district and, if required, at the block level. And apart from this, the IPC also penalizes sexual harassment under 354A, so you can make a criminal complaint by providing an imprisonment of 1 to 3 years. Now, this brings me to the end of my conversation around rights of women at workplace. So what is the ground reality? You know, the law is there, the constitution is there, you have the Maternity Benefit Act, you have the Equal Remuneration Act, you have the Sexual Harassment Act, but what is the ground reality? In spite of the fact that the law is very clear on the subject and provides for upliftment, protection, and equal rights of women, there is very little awareness for it. Very few women know about the Maternity Benefit Act. The rural, the unorganized sector, they don't even know if they have the option of maternity benefit or the Equal Remuneration Act. So there's very little awareness of rights by the women as well as the employers. Further, even when sometimes the cases are put forth by the women employees, they are brushed under the carpet. Therefore, the structures that influence existing issues such as the gender pay gap, gender-based occupational segregation, and biases in hiring need to be addressed forthwith. It is also necessary for all of us, both men and women. And I said men and women because men form 50% of our population, more than that. So, if they can help women to understand their right, to make their rights available to them, and put up a voice when wrong, to bring that is what is going to bring about social change within us and the society. So, thank you very much. Hope you get something out of this conversation.
Thank you so much there, Mrs. Mardia. I must compliment you on a power-packed session. It was a brilliant discourse. The effort that you put in terms of the research that you did, it thoroughly reflected throughout in this flawless discourse of yours. I had some odd 10, 12 questions that I had prepared, but I think you've more or less solved all of them. So to all the viewers who are watching and who were, I was completely short on words right now. I don't know what to say. So, in case if you still have any queries with respect to the session, with respect to the topic, feel free to write to us. We'll be more than happy to forward the same to our amicus for today's session, who's always willing to help out and reach out to people at large. And you can directly write to her, you can directly write to me, whatever works for you. And I really liked how you covered, different legislations from Maternity Act to Equal Remuneration to sexual offenses, etc., and etc., and how you discussed all the case laws in detail, and you also narrated the facts of the case. I'm sure this session will definitely and immensely benefit all our viewers who are watching this. And anything that you wish to say before we wrap up our episode for today?
No, just it was wonderful, and I'm so grateful for the platform you've provided me with, because I'm always very passionate about women rights, and just the fact that you let me speak on something that I believe in, and if it can help even like 5 women in understanding how they can go about their grievance, if any, or if they become aware and are able to fight for getting equal pay, I think a virtual amicus and I, as an amicus on your platform, would have done something meaningful. So thank you for this opportunity. Very, very grateful for it.
Fantastic. So, creating legal awareness and solving legal and basic complex issues was always the idea behind starting the virtual amicus. And today's amicus has done that. She's delivered it, and that kind of manifests in this session for today. So, thank you so much, Mrs. Shaambhavi Bhansali Mardia, for taking out time on a weekend for us and for our channel. And a big thank you to all the viewers for watching. Stay tuned. Next episode is on its way. Stay home, stay safe. COVID is still around. It's goodbye for now. Thank you.